The first thing I heard wasn't the judge. It was the sound of 23 chainsaws going silent, all at once. The sudden silence rolled across nearly 10,000 acres of oak forest like a wave, swallowing the echo of engines that had been chewing through my land since sunrise. Even from the steps of the federal courthouse, nearly 40 miles away, I could imagine that silence. Every logger, every truck driver, every subcontractor had received the same phone call within seconds of the judge signing the emergency order. Stop cutting. Leave everything exactly where it is. I closed my eyes. For the first time in almost 11 months, I could breathe. Across the courtroom, however, someone else looked like they had forgotten how. Rebecca Holloway, president of the Cedar Ridge Homeowners Association, gripped the edge of the defense table so tightly her knuckles turned white. She wasn't looking at the judge anymore. She was staring at her attorney, silently begging him to explain how a simple HOA dispute had somehow become a federal property rights case. He couldn't. Neither could anyone else, because nobody expected a neighborhood association with fewer than 300 homes to end up accused of organizing commercial logging operations on land they had never owned. The courtroom doors swung open as another attorney rushed inside, carrying a stack of freshly printed documents. He whispered into Holloway's lawyer's ear. The man's face drained of color. "No," he muttered. Rebecca leaned toward him. "What is it?" He didn't answer immediately. Instead, he slowly turned toward the judge. "Your Honor," his voice cracked. We've just received confirmation that every timber contract has been suspended." The judge adjusted his glasses. "By whom?" "The buyers." "And why?" Another long silence. "Because the title insurance company discovered the HOA never possessed legal harvesting rights." A murmur spread through the packed courtroom. Journalists immediately began typing. Camera operators leaned forward. Even the federal marshals standing against the wall exchanged quick glances. Rebecca shot to her feet. "That's impossible," she shouted. "Our community has used that forest for decades." The judge didn't even look up from the documents in front of him. "Using something," he said calmly, "and owning something are entirely different legal concepts." Her breathing became louder. She pointed directly at me. "This man knew exactly what he was buying. He can't suddenly erase generations of community tradition." I finally stood. It was the first time I'd spoken in nearly an hour. "I didn't erase anything." Every eye turned toward me. "I bought 9,900 acres with a clean federal title." I paused. "You tried to sell my trees." The courtroom became so quiet. I could hear someone shifting papers 3 rows behind me. Rebecca laughed nervously. "This is about firewood." "No," I replied. "It stopped being about firewood the day your board signed contracts worth millions of dollars, using my property as collateral." Even her own attorney slowly lowered his head. The judge looked toward the clerk. "Please mark Exhibit 47. The clerk placed a thick binder onto the evidence cart. Its cover contained only 6 words. "Confidential HOA Timber Revenue Agreement." Rebecca froze. Her lips parted. She looked at the binder as though she'd never seen it before. Then she whispered 4 words that changed everything. "Where did you get that?" I didn't answer. Because the truth behind that binder, and the person who had secretly risked everything to hand it to my legal team, was the reason this case had exploded far beyond a neighborhood dispute. And before any verdict could be reached, the entire courtroom was about to learn how a fight over firewood rights had uncovered one of the largest property fraud schemes our county had ever seen. People hear 9,900 acres and immediately assume one thing: money. They picture private helicopters, sprawling mansions with marble columns, and someone who inherited enough wealth to buy a forest on a whim. That wasn't me. My name is Daniel Mercer. I was 48 years old when all of this happened, and I had spent nearly 25 years building a business restoring damaged timberland across the Pacific Northwest. I wasn't a billionaire. I wasn't even close. I was a forester first and a businessman second. Every major purchase I'd ever made came after months of walking the land, studying soil reports, talking with wildlife biologists, and running numbers until 2 in the morning. Trees weren't inventory to me. They were living investments that outlasted people. The Oak Hollow Forest outside Roseburg, Oregon, was unlike anything I'd ever seen. Nearly 10,000 acres of mature white oak, Oregon black oak, Douglas fir, and winding creeks stretched across rolling hills that looked almost untouched by time. Deer crossed the old logging roads at dawn. Bald eagles nested near the northern ridge. Every spring, wildflowers painted the clearings in blues and yellows that photographs never seemed to capture. The previous owner, an elderly rancher named Harold Simmons, had spent 50 years protecting the property from over-harvesting. When I met him during the sale, he placed a weathered hand on one of the oldest oak trees near the cabin. "Promise me something." I smiled. "If I can. Don't let anyone turn this place into another subdivision." I looked around at the endless forest. "I didn't buy it to destroy it." He nodded once. "I know." That handshake meant more to me than the purchase contract. 6 months later, Harold passed away. Every time I walked the forest, I remembered that promise. The property wasn't just an investment anymore, it was a responsibility. I moved into the original cedar cabin near the southern entrance, while my small management team began surveying roads, repairing culverts, and removing invasive brush. We planned selective harvesting over decades, not clear-cutting. Healthy forests needed patience. Most days began before sunrise. Coffee, boots, maps tucked under my arm. Then hours of walking trails with my operations manager, Lucas Bennett, a former wildland firefighter who could identify tree diseases from 50 yards away. "You ever get tired of this view?" Lucas asked one morning as fog drifted through the valley. I laughed. "Not once." "Good. Why?" "Because if you ever do, I'll assume you've been replaced by an imposter." We both laughed. Life was peaceful, exactly what I wanted. The nearest residential neighborhood sat along the eastern boundary, Cedar Ridge Estates. About 260 upscale homes wrapped around a private golf course. From the county maps, only one corner of the subdivision touched my property, separated by an old fence that dated back decades. At first, the homeowners seemed friendly enough. People waved while walking dogs. Families hiked the county trail that ended before reaching my land. A retired couple even stopped by one afternoon with homemade blackberry pie. "We're glad someone finally bought the forest," the husband said. "It'll be nice knowing it's being cared for." Those words stayed with me, because they turned out to be the exception. About 3 weeks after closing, little things started happening. Nothing dramatic, just strange. One afternoon, Lucas drove back from inspecting the eastern ridge with an odd expression. "You expecting visitors?" "No." I counted 6 pickup trucks parked inside the east access road. I frowned. "My road?" "Yep." "They hunting?" He shook his head. "Cutting wood." I set my coffee down. "What do you mean, cutting wood?" "They had trailers full of split oak." I stared at him. "Did you talk to them?" "They told me everyone around here uses the forest." I actually laughed. "Uses it?" "That's what they said." I figured it had to be some misunderstanding. Maybe they thought the land was still owned by Harold. The next morning I drove out myself. About half a mile inside my eastern gate, I found fresh tire tracks leading into a grove of mature white oaks. Then I heard it. The sharp crack of a splitting maul. I followed the sound until I reached a clearing where 4 men loaded neatly cut firewood into 2 utility trailers. None of them looked surprised to see me. One even smiled. "Morning." I glanced at the stacks. "Can I help you, gentlemen?" The oldest man shrugged casually. "We're almost done." "I wasn't asking if you were done." His smile faded. "I'm asking why you're cutting trees on my property." The 4 men exchanged puzzled looks. Then one of them chuckled. "Your property?" The oldest man wiped sweat from his forehead before answering in the calmest voice imaginable. "Son," he pointed towards Cedar Ridge Estates. "The HOA owns the firewood rights." The words hit me so unexpectedly that I honestly thought I'd misheard him. "I'm sorry," I said slowly. "The HOA owns what?" He nodded as if explaining something every local resident should already know. "The firewood rights." Behind him, another man tossed another split oak log onto the trailer. "And we've had them for years." I looked from the freshly cut timber to the property markers I had personally surveyed before closing. Every stake was exactly where it should have been. Every acre belonged to me. Yet standing in the middle of my own forest were 4 complete strangers who genuinely believed they had every legal right to remove wood from it. For the first time since buying Oak Hollow Forest, a feeling settled into my stomach that had nothing to do with confusion. It was instinct. Something was terribly, terribly wrong. I kept my voice calm. I think there's been some misunderstanding. The oldest man rested the handle of his splitting maul against his shoulder. There hasn't. I reached into my truck, pulled out a laminated copy of the county survey I'd been carrying since closing, and spread it across the hood. This line right here, I said, tracing the eastern boundary with my finger, is the property line. You're standing almost half a mile inside my land. The four men barely glanced at the map. One of them shrugged. Doesn't matter. It matters quite a bit. No, another replied. The HOA lets residents collect firewood every year. I looked directly at him. The HOA can't give permission to harvest trees it doesn't own. The oldest man sighed like he'd had this conversation before. You need to take that up with Rebecca. Rebecca who? Rebecca Holloway, HOA president. He folded his arms. She'll explain it. I took several photographs of the trailers, the freshly cut logs, the stumps, and the license plates. I'm asking you one time. The men watched me without moving. Please load your equipment and leave. The youngest among them laughed. You going to arrest us? No. I folded the survey back up. But if you're still here in 10 minutes, I'll be calling the Douglas County Sheriff's Office. For a moment, nobody spoke. Then the oldest man nodded toward the road. Come on, boys. As they climbed into their trucks, he leaned out the driver's window. You won't win this. I frowned. What makes you think we're fighting? His answer stayed with me for months. Because everyone who buys this forest ends up fighting. That afternoon I drove to Cedar Ridge Estates. The entrance looked more like a private resort than a subdivision. Stone walls framed an iron gate, flower beds lined the boulevard, and a polished bronze sign welcomed visitors beneath perfectly trimmed hedges. The clubhouse overlooked a golf course so immaculate it looked painted. Inside, a receptionist greeted me with a practiced smile. Can I help you? I'm here to see Rebecca Holloway. Do you have an appointment? No. She hesitated before picking up the phone. A minute later, a woman in her late 50s stepped out of a conference room. She wore a navy blazer despite the summer heat, carried a leather binder under one arm, and smiled the kind of smile that never reached her eyes. You must be Mr. Mercer. I am. I'm Rebecca Holloway. She extended her hand. I shook it. Her grip was firm, almost competitive. What can I do for you? I found residents cutting oak trees on my property this morning. She didn't look surprised. Instead, she smiled politely. Oh. They told me the HOA owns firewood rights. Rebecca nodded. Yes. I blinked. I'm sorry? It's a long-standing community agreement. Can you show me the document? It's part of our governing history. That's not what I asked. Her smile thinned. I'll have our legal committee review what can be shared. I stared at her. So you can't produce anything? She closed her binder. Mr. Mercer, she spoke slowly, like she was explaining something to a child. Families in Cedar Ridge have gathered firewood from that forest for over 30 years. I don't care if they've done it for 100. I leaned slightly closer. Tradition doesn't override a recorded deed. For the first time, her expression hardened. You seem unfamiliar with how things work here. No, I smiled. I think I'm becoming very familiar. She folded her arms. You bought land adjacent to an established community. I bought land. Our residents have certain expectations. My deed has certain boundaries. A few homeowners passing through the lobby had stopped walking. They were listening now. Rebecca noticed them. Her posture changed instantly. Her voice became louder. Mr. Mercer, our community has peacefully enjoyed access to that woodland for decades. I've never questioned peaceful access to public trails. You are denying residents resources they've always depended on. I'm stopping trespassing. Her eyes narrowed. So that's your position. It's called ownership. The silence between us felt heavy. Finally, she smiled again. But it wasn't friendly anymore. It was calculated. I'd encourage you, she said softly, to reconsider before creating unnecessary conflict. I'd encourage your residents to stay off my land, she laughed quietly. I don't think you understand who you're dealing with. Before I could answer, she turned and walked back toward the conference room. The conversation was over, or so I thought. 3 mornings later, Lucas burst into my office without knocking. You need to come outside. I grabbed my keys. What happened? He pointed toward the eastern entrance. You're not going to believe this. Parked across my access road were 3 HOA maintenance trucks. Workers wearing bright safety vests were installing a brand new wooden sign directly beside my gate. I stopped dead. Painted in bold green letters, it read, Cedar Ridge Community Firewood Collection Area. Password, resident access. I stared at the sign in disbelief. A man with a post hole digger smiled at me. Morning. Who told you to put that there? He looked genuinely confused. The HOA board. I pointed to the ground beneath his boots. You're standing on my property. He shrugged. They told us they had permission. Before I could respond, another truck pulled up, then another. Rebecca stepped out of a black SUV, followed by 2 board members carrying folders. She didn't even acknowledge me. Instead, she clapped her hands once and addressed the workers. Go ahead. Within seconds, chainsaws started again. I reached for my phone. I'm calling the sheriff. Rebecca turned slowly and smiled. You should. An hour later, 2 sheriff's deputies arrived. I expected them to stop the logging immediately. Instead, one deputy looked from me to Rebecca, then sighed. Looks like we've got another property dispute. Rebecca calmly handed him a thick folder. The deputy flipped through several pages, nodded slowly, then turned toward me. Mr. Mercer. His expression wasn't accusatory, but it wasn't reassuring either. I'm going to need to see your paperwork. Standing there, watching strangers cut trees while law enforcement questioned my ownership instead of theirs, I realized this wasn't a misunderstanding anymore. Someone had spent years building a paper trail, and whatever was inside Rebecca Holloway's folder was convincing enough that even the sheriff's office wasn't sure who actually controlled my forest. The younger deputy accepted the folder Rebecca handed him with both hands. He flipped through it slowly, his eyebrows rising every few pages. Rebecca stood beside him with complete confidence, almost enjoying the moment. You'll find everything is documented, she said. This arrangement predates Mr. Mercer's ownership by decades. I held out my own packet. My deed, title insurance policy, county survey, and closing documents. The deputy accepted them and compared the 2 stacks. For nearly 5 minutes, nobody spoke. Chainsaws had stopped again, but only because the workers were waiting for instructions. Finally, the older deputy closed both folders. This isn't something we're going to decide on the side of a logging road, Rebecca smiled. I understand. He turned toward the workers. For today, everyone packs up and leaves. Rebecca's smile disappeared. Deputy, our contractors. I said everyone. She clenched her jaw. We have scheduled work. You can reschedule it. Then he looked at me. And Mr. Mercer? Yes? If anyone comes back onto this property without your permission, before this gets sorted out, call us immediately. Rebecca's eyes narrowed. She clearly hadn't expected that ending. The workers loaded their equipment while she climbed back into her SUV without another word. As her vehicle disappeared down the road, Lucas let out a slow breath. That could have gone worse. It isn't over. No. He looked toward the fresh stumps scattered across the clearing. I don't think it's even started. The following morning, I drove to my attorney's office in downtown Roseburg. Sarah Whitaker had built a reputation across Oregon for handling complex land disputes involving ranches, timber companies, and conservation easements. She wasn't flashy. Her office walls held survey maps instead of expensive artwork, and every available shelf was packed with county record books. She listened without interrupting as I explained everything. The logging, the HOA, Rebecca, the deputies, the mysterious Firewood rights. When I finished, Sarah leaned back in her chair. Tell me something. What? Did anyone ever mention an easement during closing? No. A timber lease? No. Profit-sharing agreement? No. She nodded once. Good. I frowned. Good? Because if one existed, your title company would have found it. She stood and walked toward a filing cabinet. Let's verify that. Within an hour, she had requested certified copies of every recorded document affecting Oak Hollow Forest over the last 60 years. I don't like assumptions, she said. I like records. 3 days later, we met again. Her conference table was covered with maps, old deeds, subdivision plats, tax records, survey photographs, county commission minutes. There had to be over 200 pages spread across the room. Sarah slid one document toward me. This is Cedar Ridge Estate's original subdivision map from 1989. I studied it. The neighborhood boundaries ended exactly where mine began. No overlap. Correct. She placed another document beside it. This is the HOA declaration. I skimmed the pages. Rules, architectural standards, maintenance obligations, assessments. Nothing about my forest. What am I missing? Nothing, she smiled slightly. Neither am I. Lucas leaned over the table. So where are these firewood rights? Sarah folded her hands. That's becoming a very interesting question. The next week became an obsession. Every morning, Sarah's paralegal requested more records. Every afternoon I walked the eastern boundary, documenting fresh stumps, tire tracks, and damaged fencing. We installed motion-activated cameras along every vehicle entrance. By the third night, they captured exactly what we'd suspected. Residents entering after dark, pickup trucks, utility trailers, people carrying chainsaws. One camera even recorded a man unlocking my gate with a key. I watched the footage twice. How does he have a key? Lucas shook his head. He shouldn't. We changed every lock the next morning. A retired county surveyor named Frank Delaney became our next stop. Frank had spent 38 years mapping Douglas County before retiring. If anyone remembered old property lines, it was him. He spread a yellowed aerial photograph across his kitchen table. I surveyed this forest back in '91. He tapped the eastern boundary. People always tried pushing this line. Why? He chuckled. Because valuable timber makes people creative. I pointed towards Cedar Ridge. Did the HOA ever own any part of the forest? Frank laughed outright. Not even an inch. So where did this firewood story come from? His smile faded. I've wondered that myself. He disappeared into another room. A minute later, he returned carrying a dusty cardboard tube. Inside was an original survey blueprint. He unrolled it carefully. Every boundary matched my deed exactly. Then he pointed toward a handwritten notation in the corner. See this? Someone had written, "Private timber reserve. No public harvesting rights conveyed." Frank looked at me. I wrote that. Why? Because people kept asking. My pulse quickened. Who? He thought for a moment. I remember one developer. What developer? The company that built Cedar Ridge. That afternoon, Sarah called. Her voice sounded different, sharper. Daniel, what did you find? I didn't. Then what happened? I found what wasn't filed. I frowned. What does that mean? The HOA keeps referring to an agreement. Right. I searched county records. And? Nothing. No firewood agreement? No. No easement? No. No timber reservation? No. I leaned back in my chair. So they've been lying. Maybe. She paused. Or maybe someone intentionally avoided recording it. Can they do that? They can. Would it be enforceable? Usually not. Another long silence. Then she added one sentence that made every hair on my arms stand up. I think we need to know what happened before Cedar Ridge was ever built. 2 days later, Sarah called me into her office. She didn't say much over the phone, just, "Come now." When I arrived, a single file sat in the center of her conference table. It wasn't from the county recorder. It wasn't from the title company. The cover was faded blue, with the logo of a long-defunct real estate development firm. Across the front, stamped in red ink, were the words, "Confidential, internal land acquisition file." Sarah looked me straight in the eye. I don't know who mailed this to my office. I slowly opened the cover. The very first page was a memo dated March 14th, 1988. Halfway down the page, one sentence had been underlined in black marker. The HOA must never be informed that the timber parcel was excluded from the final sale. I looked up at Sarah. Neither of us spoke. Because in that instant, we both realized the firewood rights dispute might have been built on a lie that had survived for nearly 40 years. And someone, somewhere, had finally decided it was time for the truth to come out. I read the sentence again. Then a third time. The HOA must never be informed that the timber parcel was excluded from the final sale. The words felt unreal. Not because they were complicated, because they were devastating. For months, Rebecca Holloway had spoken with absolute confidence. She had insisted the HOA possessed historic firewood rights. She had repeated it to homeowners, deputies, contractors, and even attorneys, as though it were unquestionable fact. Yet the first page of this internal file suggested something entirely different. The homeowners themselves might never have known the truth. Sarah carefully closed the folder. "We're not celebrating." I looked at her. "Why not?" "Because one anonymous document doesn't win a federal case." She was right. It was explosive. But it still had to be authenticated. "We need to prove where this came from," she continued. "If we can't establish its origin, opposing counsel will argue it's fabricated." Lucas nodded. "So what's next?" Sarah reached for her legal pad. "We identify every executive involved in Cedar Ridge's original development. Some are probably retired. Some may have moved. Some may have passed away. And if we find one, she gave a small smile, we ask questions. The following week became a race against time. Sarah's investigator, Michael Torres, tracked down corporate records from the now defunct developer. Most of the company's officers were gone. One had died years earlier. Another was living in Florida with advanced dementia, but one name stood out: Richard Lawson, former land acquisition director, 81 years old, living less than 90 miles away. When Michael called to request a meeting, Richard surprised everyone. I've been waiting for somebody to ask. His farmhouse overlooked a valley of grazing cattle. He greeted us wearing faded jeans and an old denim jacket that had probably outlived 3 trucks. After introductions, he motioned toward his porch. I know why you're here. Sarah opened the blue file. Have you seen this before? Richard adjusted his reading glasses. The moment his eyes landed on the cover, his shoulders sank. I hoped that thing had disappeared forever. You recognize it? I wrote half of it. No one spoke. He looked toward the hills for several seconds before continuing. The developer bought 2 separate properties back then. One became Cedar Ridge, and the other, he looked directly at me. Your forest. I leaned forward. They were always separate, always. Then why do people believe otherwise? Richard let out a long sigh. Marketing. Sarah frowned. What do you mean? The sales team wanted buyers to think they'd have permanent access to the woods, but they didn't. No. So they lied. Richard rubbed his forehead. They called it future recreational access. Were any legal rights ever transferred? He answered without hesitation. Never. Sarah placed another document in front of him. Would you be willing to testify under oath? Richard looked at the papers for almost a minute. Then he quietly said, I should have done it 30 years ago. I thought we finally had momentum. Then the retaliation started. First came the letters. Certified envelopes arrived almost daily. One accused me of blocking historic community resources. Another claimed I had destroyed shared cultural traditions. A third demanded nearly $1.8 million in damages for interference with community rights. Sarah laughed when she read that one. They're throwing everything they can think of at the wall. Then local social media exploded. Someone created a page titled, Save Our Forest Access, except it wasn't my forest anymore. According to hundreds of comments, I was the villain. Greedy, heartless, an outsider. People I'd never met accused me of stealing from elderly residents. One comment read, he's trying to freeze seniors who depend on free firewood. Another, millionaire buys our forest and locks everyone out. Lucas tossed his phone onto my desk. This is getting ugly. It already was. No, he pointed toward the screen. Look. Someone had posted my home address. 3 nights later, headlights appeared outside my cabin. Not one vehicle. 5. Security cameras showed people standing at the entrance, shouting, Coward! Open the gate. This belongs to the community. Someone threw a log against the fence. Another spray-painted, Thief, across my entrance sign. Lucas called the sheriff while I stayed inside. The deputies dispersed the crowd before things escalated, but the message was unmistakable. Someone wanted to intimidate me into walking away. The next morning, Sarah arrived with coffee. You okay? I've had worse mornings. She looked at the vandalized gate. I doubt that. For several moments we stood without speaking. Finally, she handed me a thick binder. Inside were deposition transcripts, corporate records, Richard Lawson's sworn affidavit, original subdivision maps, Frank Delaney's survey, security footage logs, certified county records, title opinions, expert reports, months of work. She placed one hand on the binder. This is our case. I flipped through hundreds of pages. It was overwhelming. What are our chances? She didn't answer immediately. Instead, she looked toward the damaged entrance. They're not trying to settle anymore. No. They're trying to scare you. I noticed, she smiled. That's usually what happens when the facts stop cooperating. 2 days later, Michael Torres rushed into Sarah's office carrying another sealed envelope. I think we found it. Sarah looked up. What? The smoking gun. He carefully removed a contract from the envelope. It wasn't between the HOA and homeowners. It wasn't between the developer and the county. It was between the HOA and a regional timber company, signed just 8 months earlier. The agreement authorized the sale of commercial oak harvested from my property. Estimated value, $6.4 million. Revenue distribution, 40% to the logging contractor, 60% to Cedar Ridge Homeowners Association. At the bottom of the final page sat Rebecca Holloway's unmistakable signature. Sarah stared at it for several silent seconds, then she closed the folder. They weren't gathering firewood. I looked at the contract, feeling equal parts anger and disbelief. They were running a commercial timber business, and, Sarah replied quietly, they signed contracts for land they never owned. She met my eyes. It's time. Time for what? She smiled for the first time in weeks. Federal court. The federal courthouse in Eugene looked nothing like the county courthouse where minor property disputes were usually heard. Everything about it felt heavier. The marble floors reflected every step. Federal marshals stood quietly at every entrance. Reporters lined the hallway outside courtroom 4B, whispering into cameras as attorneys hurried past with rolling cases full of exhibits. By the time Sarah and I reached our table, nearly every seat in the gallery was occupied. Homeowners from Cedar Ridge filled one side. Local ranchers, timber operators and landowners filled the other. No one was smiling. This case had grown far beyond a disagreement over firewood. It had become a test of whether a homeowners association could create rights that had never legally existed. Judge Eleanor Hastings entered precisely at 9 o'clock. Please be seated. The room settled into complete silence. She adjusted her glasses and looked over the docket. Mercer versus Cedar Ridge Homeowners Association. Her eyes moved from Sarah to the defense table. I trust both parties are prepared. Sarah stood. We are, Your Honor. Rebecca's attorney, Martin Ellis, rose immediately afterward. So is the defense. The judge nodded once. Proceed. Sarah walked to the center of the courtroom with only a single folder in her hands. She didn't begin with legal terminology. She began with a question. Your Honor, she turned slightly toward the bench. If someone parks their car in your driveway for 30 years, does the driveway become theirs? Judge Hastings answered almost immediately. No. Sarah nodded. If someone fishes from another person's dock every summer, do they eventually own the lake? No. She turned toward Rebecca. Then how does repeated trespassing transform into legal ownership of commercial timber? Silence. Sarah paused just long enough for the question to settle over the courtroom. This case is not about tradition. She placed my deed on the evidence screen. It is about title. One document appeared after another. The recorded deed, the certified survey, county property maps, tax records. Every exhibit pointed to the same conclusion. The forest belonged to me. Every acre, every tree, every inch. Martin Ellis approached the jury box with practiced confidence. Ladies and gentlemen, he gestured toward Rebecca. Cedar Ridge residents have relied upon this woodland for generations. He displayed photographs of families carrying bundles of firewood, children walking trails, holiday gatherings around fireplaces. This isn't corporate greed. He looked directly at me. It's community. Several homeowners nodded. For a brief moment, I could feel the emotional weight shifting. Then Sarah stood. Permission to cross? Granted. She walked toward the photographs. Mr. Ellis. Yes? Can you identify a single document granting your client ownership of those trees? Ellis hesitated. Our position is based upon long-standing... A document, she interrupted gently, not a tradition. He remained silent. A deed? Nothing. An easement? Nothing. A timber reservation? Again, nothing. The silence became uncomfortable. Judge Hastings leaned forward. Counsel? Ellis slowly returned to his table. Rebecca Holloway took the witness stand just before lunch. She appeared composed, confident, almost rehearsed. Sarah approached with a legal pad. Mrs. Holloway. Yes. How long have you served as HOA president? 9 years. And during those 9 years, did you believe Cedar Ridge possessed firewood rights? Absolutely. What was that belief based upon? Our historical records. Sarah nodded. Can you produce them? They're part of our association archives. Were they recorded with Douglas County? I don't know. Sarah picked up another document. Did you ever personally verify ownership before approving logging operations? Rebecca shifted slightly. Our attorney advised us. That's not my question. Another pause. No. So you never confirmed the HOA actually owned commercial harvesting rights? We believed we did. Sarah stepped closer. Belief and ownership are different things, aren't they? Rebecca didn't answer. The judge looked over her glasses. You may answer. Yes. After lunch came Richard Lawson. At 81, he walked slowly to the witness stand with the help of a cane. He took the oath. Sarah smiled warmly. Mr. Lawson, what was your position with Northwest Horizon Development? I handled land acquisitions. Were you involved in Cedar Ridge Estates? I was. Were the subdivision and Oak Hollow Forest sold together? No. Were timber rights ever transferred to the HOA? No. Did marketing materials suggest otherwise? Richard closed his eyes briefly. They shouldn't have, but they did? Yes. Murmurs spread through the gallery. Ellis stood immediately. Objection. On what grounds? The judge asked. Speculation. Sarah calmly held up an exhibit. Your Honor, Exhibit 32. The courtroom screens illuminated with a 1989 promotional brochure. Across the bottom, bold letters read, "Exclusive community access to beautiful woodland areas." Judge Hastings studied it carefully. Overruled, Richard continued. Sales staff exaggerated access to help sell homes. Were legal rights conveyed? No. Ever? Never. By the fourth day of trial, the defense looked exhausted. Their witnesses contradicted one another. One board member claimed the HOA had inherited the rights. Another insisted they had purchased them. A third admitted he'd never seen any supporting documents. Then Sarah quietly approached the evidence cart. She removed a thick binder. The same binder Rebecca had stared at during the emergency hearing. Your Honor. She held it up. The plaintiff moves to admit Exhibit 47. Judge Hastings nodded. Admitted. Sarah opened it slowly. Inside was the commercial timber contract, signed 8 months earlier. She projected the signature page onto the courtroom screen. Every person in the gallery leaned forward. Mrs. Holloway. Rebecca looked visibly uneasy. Is that your signature? Yes. You authorized the sale of commercial oak from Oak Hollow Forest. We believed. Please answer yes or no. Rebecca swallowed. Yes. Sarah turned one more page. Would you read the highlighted sentence aloud? Rebecca stared at the paper. She didn't move. The judge spoke firmly. The witness will answer. Rebecca's voice barely rose above a whisper. Seller warrants that the association possesses full legal authority to harvest, market, and transfer all merchantable timber. Sarah let the words hang in the air. Then she asked the question that froze the entire courtroom. Mrs. Holloway. She looked directly into Rebecca's eyes. If you never verified ownership. Sarah paused. How could you legally warrant something you didn't own? Rebecca opened her mouth. No words came out. Across the room, even her own attorney slowly lowered his head. Judge Hastings looked down at the exhibits, then back at the witness stand. The expression on her face had changed completely. For the first time since the trial began, it was impossible to tell whether she was angry or stunned. The courtroom remained silent for so long that I could hear the ticking of the antique wall clock behind the judge's bench. Rebecca Holloway sat frozen in the witness chair. Her attorney no longer whispered advice. He simply stared at the table in front of him. Judge Eleanor Hastings closed the exhibit binder and folded her hands. Counsel, she said calmly, I've heard enough. Every person in the courtroom instinctively straightened in their seat. The judge looked first at Sarah. Anything further from the plaintiff? Sarah stood. Only this, Your Honor. She glanced toward me before addressing the bench. Mr. Mercer did not purchase uncertainty. She rested one hand on the evidence table. He purchased legally recorded property after a federally insured title search. She pointed toward the exhibits. The defendant produced no recorded deed, no easement, no timber reservation, no conveyance, and no enforceable contract granting harvesting rights. Her voice remained steady. What they did produce was a commercial logging agreement in which they claimed ownership they never possessed. She paused. The law protects good faith mistakes. Then she looked directly at Rebecca. It does not protect profitable ones. Sarah returned to her seat. Judge Hastings turned toward the defense. Mr. Ellis. Rebecca's attorney stood slowly. His shoulders looked noticeably lower than they had on the first morning of trial. Your Honor, he hesitated. My client acted upon a long-held understanding within the community. The judge raised an eyebrow. Understanding is not title. No, Your Honor. Custom is not ownership. No. She leaned forward. And belief is not legal authority. Ellis lowered his head. No, Your Honor. There was nothing else to argue. Judge Hastings removed her glasses. This court has reviewed the deeds, surveys, county records, expert testimony, sworn affidavits, corporate documents, security footage, and the defendant's own commercial timber contracts. She looked around the courtroom. The evidence is overwhelming. My heartbeat echoed in my ears. The court finds that Oak Hollow Forest, including all standing timber and associated harvesting rights, has at all relevant times been the exclusive property of the plaintiff. A murmur swept through the gallery. The judge continued. The Cedar Ridge Homeowners Association possessed no recorded ownership interest, no easement, no profit interest, and no legal authority to authorize commercial logging on the plaintiff's property. Rebecca slowly closed her eyes. Judge Hastings wasn't finished. The court further finds that the defendant knowingly represented ownership interests to third parties without conducting even minimal legal verification. She looked directly at Rebecca. That conduct was reckless. Then came the words I had waited nearly a year to hear. The court permanently enjoins Cedar Ridge Homeowners Association, its officers, contractors, agents, members, and assigns from entering, harvesting, marketing, selling, or otherwise interfering with the plaintiff's property. I finally exhaled. But the next ruling shocked even Sarah, because the evidence establishes substantial commercial activity involving property outside the defendant's ownership. The judge looked toward the federal clerk. This matter is referred to the United States Attorney and appropriate federal agencies for further review regarding potential fraud, false representations, and related financial violations. The courtroom erupted. Reporters practically sprinted toward the hallway. Federal marshals immediately called for order. Rebecca's face turned completely pale. Outside the courthouse, television cameras waited on the steps. Microphones appeared from every direction. Mr. Mercer, did you expect to win? Will you sue for additional damages? Do you believe criminal charges are coming? I stopped beside Sarah. I bought a forest. The cameras became still. I never imagined I'd have to prove I owned my own trees. That quote aired on regional news that evening. By sunrise the next morning, national legal publications were covering the case. Property rights organizations requested copies of the ruling. Timber associations cited it in newsletters. HOA reform groups discussed it across the country. The consequences for Cedar Ridge came quickly. Within 2 weeks, Rebecca Holloway resigned as HOA president. 3 other board members followed. The association's insurance carrier denied coverage for much of the litigation after determining the commercial logging activities fell outside normal HOA operations. The logging contractor immediately filed its own lawsuit against the HOA, seeking reimbursement for millions in cancelled contracts and equipment costs. Several homeowners attended emergency meetings demanding answers. Many of them looked genuinely devastated. An elderly man approached me after one meeting. I've lived there 27 years. He removed his baseball cap. They told us those rights were real. I believe you. He shook his head sadly. We never wanted commercial logging. That sentence stayed with me. Most residents hadn't been villains. They had trusted the people elected to represent them. A month later, Sarah and I walked through the eastern section of Oak Hollow Forest. Fresh spring leaves had already begun to cover the scarred clearings. Sunlight filtered through hundreds of untouched oaks that would never become lumber. Lucas joined us carrying a clipboard. Good news. What now? The Wildlife Survey, he smiled. The eagle nests are still active. I looked toward the tallest ridge. Harold would have liked hearing that. Lucas nodded quietly. I think so. I stood beside one of the freshly cut stumps left behind by the unauthorized logging. Its rings told a story stretching back more than a century. Someone had reduced that life to a few stacks of firewood and a line item in a commercial contract. I placed my hand on the weathered wood. I couldn't save every tree. Sarah stood beside me. No, she smiled. But you saved the forest. For the first time since this nightmare began, I believed she was right. Several months have passed since the federal court ruling, and Oak Hollow Forest has settled back into the peaceful rhythm that first made me fall in love with it. Every morning, I still walk the same trails with a cup of coffee in my hand. The deer have returned to the eastern meadows, the bald eagles continue nesting above the northern ridge, and thousands of oak trees stand exactly where they belong, rooted in the ground instead of marked for profit. Some of the stumps left behind by the illegal logging remain untouched. I chose not to remove them. They're quiet reminders that protecting your property isn't always about fences or locks. Sometimes it's about having the courage to stand your ground when everyone around you insists you're wrong. Looking back, I don't think the biggest lesson was about homeowners associations or even the legal system. It was about never confusing confidence with truth. People can repeat the same story for decades, but repetition doesn't turn fiction into fact. Documents matter. Evidence matters. And when the truth is finally uncovered, it has a way of speaking louder than the loudest accusation. If you've ever faced an HOA dispute, a property boundary conflict, or a situation where someone claimed rights they didn't actually have, I'd genuinely love to hear your story. Have you ever had to fight to protect something that was legally yours? Share your experience in the comments. I read as many as I can, and your story might help someone else facing a similar battle. If you enjoyed this story, please like, subscribe, and turn on notifications so you don't miss future stories of property rights, legal battles, and real estate conflicts. Thank you for spending your time with me today. Until next time, remember, the strongest defense isn't the loudest voice. It's the truth, backed by the evidence. End.